will communicate. Okay, so let us start. So in my line of everything, I like starting with somebody's microphone is on. That person is called Foro Ahmed. Foro Ahmed, your microphone is on. Zima your kid. It's okay. Now, I like starting with civil because I like civil. Civil is the easiest, so I usually like starting with civil because it sets the mood for everything. Civil is easy, very easy. It's easy to pass civil than to pass probate. So I want you to know that at the back of your mind, it is very easy for you to pass civil than to pass that thing you're calling trial advocacy. Very easy to pass civil because civil has a formula and it has a procedure. That is all. So you just need to understand the procedure and then you'll be fine. So we start with civil every Monday and Saturdays. We'll be doing civil. We'll try and make it at 8:15 so that we are done early. In case of any adjustment, we'll see. So in terms of civil litigation, like I've said, we will try and see the content, and also we will try and go through the past papers, and that is the past papers that have been done all the way from the April of 2024 down to June of 2021. And the reason for that is because CLS changed the mood and the mode of setting, and that has been seen in that period, June of 2021 to the last sitting. Okay, so we will try and look at all those past papers and see what is it that they've been setting or what is it that is in those papers so that we are all on the same page. So you need to understand civil litigation from civil procedure. Okay, it is one and the same thing, but in your undergraduate, whichever school you went to, you might have done what is called civil litigation, the theory and the law, except for those who went to that campus. You know them, they don't do that. So everyone else, they did civil. Now, the one that you did in campus is a little bit different from this one because we are now focusing on the practical aspect of civil litigation. Okay, now there are two types of litigations. At any time, this criminal litigation and the civil litigation. Okay, you could either be approaching court through a civil suit or a criminal suit at any time, generally at any time. Okay, now on the side of civil, you need to understand that civil litigation is governed by the Civil Procedure Rules 2010 and the Constitution of Kenya 2010 as well. Okay, so when I say that civil litigation is very easy, what I'm saying is that the first thing you want to make your friend is the Civil Procedure Rules. As easy as that, Civil Procedure Rules. You will not pass this unit if you don't understand the Civil Procedure Rules. You cannot even try. Okay, so what is it that you need to understand first? You need to understand what is civil litigation. Okay, and it's very simple. The process of you approaching the court with a dispute that is of civil nature. That is all. Civil litigation. So when does it begin? It begins from the point when you file, okay, until the point that the court gives the final decision. So we are talking about Order 1 all the way to Order 53, when the court finally makes a judgment or a ruling that disposes of the matter. That is civil litigation. So your work is to understand what are the procedural aspects going through that. Where do you start from? What do you do? After this, after that, after that. It's a very simple thing, and I really hope that you get to understand that. The second thing you need to understand is the procedure itself, like I've already mentioned. Now, the civil procedure rules is arranged according to the procedure itself. It means you can't start from Order 34 on the interpleaders and then come to Order 1, parties. You start from the parties. If you come from the parties, so Order 1, 2, 3, and 4, they all come together. And then immediately you go to Order 5, and then Order 6, and then 7, and then you go to 8. After 8, we go to 10. Okay, and then after 10, you know it is 11, is 12. And then after that, the miscellaneous provisions of 14, 13, 17, and 18, we go all the way to 19, 21, and then 22 of decrease. And then we jump all the way to 23. So there's a list of, I will share that list later, but there's a list of orders that you need to understand. Again, don't go reading the civil procedure rules word for word. You can do that, but it will take some time. Okay, the best way to do is to have a group. Through these calls, I will be emphasizing on the fact that you need to have a group. You need to have a group. And when I say a group, you need to have a study group. 2, 3, 4, 5 friends of yours that share the same thing. So if it is civil, you can divide the orders amongst yourself, and then it becomes easy to understand. Okay? And then we will talk about the question of taking instructions, and then the question of letters. So in terms of letters, we have 2 letters. The first letter is an opinion, and the second letter is a demand letter. And then we will talk about the decision to litigate. And then that decision will now usher us in the next topic. So I want you to work with us or work with me, but I want you to really unlearn some of the things that you've learned and make it easy for yourself to learn again. Be easy on yourself. Don't be hard. I will try my best to use the simplest of language that I can afford to convey this information. So that is what we are looking at. So the first thing you need to understand is the procedure itself. Okay, now I've said that close to around 20 orders that you need to understand, 21, 22 orders that you need to understand very well, because they're rampant, they will ever be set, because they're the core aspects of the procedure. Okay, all the way from order 1 to order 53. So 20 of them, 21 of them. So please download your civil procedure rules. That is the first one. Okay. The next thing you need to understand is, at what point do you begin? At what point do you initiate? Or at what point is civil litigation supposed to start? So the first thing is the dispute and taking of instructions. So a dispute will normally arise. Okay, like I've said, guys, this entire civil procedure is all about knowing what is supposed to happen at any time during the process. Are we together? So you have a dispute. How do you move with this dispute until the very end? That is the entire thing. There's nothing complicated about it. It is just, you have a dispute, your client has a dispute. How do we handle that dispute from the point it arises until the point it has been disposed of by the court? So it's just that, the procedure before the court. Simple. Don't complicate it. So taking instructions. So normally a client will come to your office, and this is related to something you'll do in trial advocacy, the question of the client-advocate relationship, also in professional ethics. So somebody becomes your client the moment they approach you with a case, and you opt to take up that case. Of course, there are aspects that will go into you taking the case or you not taking the case. That is not a subject of this class. But what is important is that you need to understand that civil litigation begins at the point where you take instructions. Now, under that, you need to understand what are some of the dynamics of taking instructions. How do you take instructions? Very, very important. You need to know when a client approaches your office or comes to your office, the first thing you need to understand or need to ensure is client confidentiality. So it means the place or the environment in which you're going to get that instruction should be the one that ensures the client confidentiality, and that is confidentiality of the information or the integrity of the information that is being relayed by the client. Okay, so those are obvious things. You need to avoid distractions, welcome the client, offer them something to drink if they're drinking something, make them feel comfortable, and make sure that you take the notes, you ask questions, you discuss the ethical aspects, you also discuss the questions to do with the fee. And then you can do a follow-up on the issues that have been issued. It's just all about that. You take instruction. So once you take that instruction, then the next thing you're going to do is to go straight into the first letter. Now the client has given you their story. the next thing you're going to do is to give a legal opinion. Now, legal opinion will come in two forms. The first one is you can give them a verbal opinion or advice on the spot that, hey, this matter relates to this, and therefore this is what you're going to do. That is a legal opinion in itself. Or you can prepare a letter, which is a legal opinion. So either way, you must give a legal opinion. If a friend of yours texts you or calls you and say, hey, Wakili, a quick one, that is already that person giving you instructions, giving you their instructions. And then the answer that you're going to give is a legal opinion. Okay, so that is the first letter. So preparation of legal opinions, we will look at how, of course, at this stage, I think you guys have already seen legal opinions. You've drafted a few, you've known how they're supposed to be structured, and it's okay. You understand that. We still try and look at that. But like I've said before, legal opinions are four letters that are so similar in nature that you need to understand how to prepare, which is the same thing. We have legal opinions, we have submissions, we have judgments, and we have rulings. It is the same thing, but addressed to different people at different stages. So how you draft a legal opinion is the same as how you draft a submission, is the same as how you draft a ruling, is the same as how you draft a judgment. So if you know how to draft one of them, you know how to draft all of them. The only difference is judgment and rulings will be addressed to the parties. Submission is addressed to the court, and then a legal opinion is addressed to your client. But it is the same thing, same format, the FIRAC rule, the facts, the issues, the rule, the analysis, and the conclusion. That is the format that every legal opinion takes, every submission takes, and every ruling takes, and also every judgment will take, or even every advice. You'll be told advise person XYZ on how to do this. Are we together? Maybe you guys have been taken by the aliens. Are you guys there?
We are
Yes,
here.
we are following.
Yes, we are.
All right. So that is the first one. That is the first aspect. So you draft a legal opinion. So like I've said, a legal opinion is just the FIRAC, the fact, the issue, the rule, analysis, and the conclusion. And then that legal opinion, you're supposed to send it to your client. And then after your client goes through your legal opinion and considers your advice, they will now give you instructions to proceed and prepare a demand letter, to demand from the other person. And that gives us the second letter, which is the demand letter. That is the second one, which is the demand letter. So the demand letter falls at that point. Okay, so a demand letter again is just a letter containing the facts and the demands. It's a demand letter, the facts and the demand. Okay, now sometimes you will have the notice of intention to sue within the demand letter. We don't have as an entire document called a notice of intention to sue. Normally it's just a demand letter. And then the last paragraph of that demand letter will normally have what you're calling a notice of intention to sue, where you're simply saying that take notice that if you don't pull down the comments on your Twitter account that my client considers defamatory, then we shall sue. If you don't pay this specific amount of money within this specific period of time, we have very strict instructions to unleash our legal machineries. You know, lawyers like sideshows on that paragraph. They threaten things that they can't even do themselves. Okay, so that is the notice of intention to sue. You're clearly telling them that you are going to sue. Certain matters you must give a notice of intention to sue. It means your demand must have that notice of intention to sue. It means if you just do a demand but you don't give them the intention to sue and you proceed and sue, then sometimes you'll be denied cost. That is a discussion for another time. So that is the demand letter. That is a demand letter. So also we will look at, we will have sessions for drafting, and of course we look at some of those things and how you're supposed to frame them. Of course, at this point, at this time, I'm assuming that you must have interacted with a demand letter or a legal opinion. Or maybe unless you're just waking up from a coma, or you were stolen by the aliens and they just brought you back to the country. But ordinarily, I'm expecting that all of us, you might also have done a demand on on your own. You might, maybe a friend of yours was asking about something, or a friend of yours owed you some money and you told them, my friend, nilipe bana. If you don't pay me, mimi na wewe tumemalizana. That is a demand one. That's a demand letter. So it's a very simple thing. I gave you money on this date. You said you'll return, but you've not returned. Please return. If you don't return, tupatane, small claims. That is a demand. So don't over legalize these things. They're just the normal things that happen in your daily life. Legal opinions, you do them all the time. You're a wakili, you're the hope of your village. You keep giving people advice on what to do at what instance. That is a legal opinion. You've been told to demand things from other people. That is a that is a demand letter. So there are things that we do all the time. So don't overcomplicate it. If you want to fail this unit here, there are two things you're going to do. The first thing you're going to do is to overcomplicate your life. And then the second thing is not relevant now, but it's about time management. We'll talk about it later in time. So very, very simple. So make it simple. Life is already hard. People are already suffering. The economy is doing very bad. Inflation is going up. The dollar is going up. So don't complicate your life with this one also. Make it as easy as it can get. Tuko sawa? We are good?
Yes, you are good.
You're good.
Tuko sawa.
Okay.
Tuko sawa.
All right. Sawa. So that said, that closes the first thing I wanted to mention so that we are on the same page. The first thing I've said is you need to understand the general introduction to civil. Civil simply means we have a dispute before the court, the civil courts. Okay, how do we navigate or maneuver through the court process until we get the judgment or the ruling that our client is looking for? So at any point of this, whatever exam you're going to do, the examiner is simply asking, what is the best advice in this case? That matter will always be in court or going to court. It is civil litigation. Okay, so once you understand that, then you need to understand now the key aspect, the framework for civil litigation. The first one, which is the Bible of this, is the civil litigation. Civil procedure rules. The civil procedure rules are now the canons that highlight the procedure. And I've said, and again, I'll say again, civil procedure is simple. Don't complicate it. It is very simple. Okay, just understand the rules. Some of you are in this class. They're sleeping like normal, 8 hours, 9 hours a day, eating 3 times, drinking 10 liters of water every day, and they're manifesting every time, but they haven't even taken the time to download the civil procedure rules. Okay, so as you go to bed tonight, please take 1 hour of your time. If you're sleeping 9 hours, take 1 hour, download the rules and read. Life will be fine. So please. Some of you have it, but they don't read it. Just take time. It's a very boring thing to read. Yes, very, very extremely boring. But you have to force yourself on it. And we've said all the time, instead of forcing love mahali, hiyo mapenzi unapeana bure huko nje, leta hapa. Okay? Force yourself to love civil. Sipende mwenye kupendi. If you love civil, civil will always reciprocate. Please. That is that. So the civil procedure rules is very important. The next thing you need to understand is the Constitution of Kenya 2010. You can't be a wakili, a whole hope of the village, but you don't understand your constitution very well. Now, the Bill of Rights is very important. The Bill of Rights is very important when it comes to civil. Again, don't dream about passing civil if you don't have time to go through the Bill of Rights. It's not so complicated. It is just Article 19 all the way to Article 5.3. Okay, just that and a few other articles like 159 and 260. It's very, very simple. Please, just read the Bill of Rights. So the Bill of Rights will help you most when it comes to our topic 5 or topic 6 in terms of institution of suits. You'll understand how the Constitution comes in when it comes to petitions and judicial review. Are we together? So please download the Constitution. Download the Constitution and read the Bill of Rights. Like I've said again and again, you don't have to love it. Nobody reads the Constitution for fun. Okay, so just read it, force yourself to read it, discuss it with a friend, and you will be fine. Some of you here are lone rangers. They keep saying they're lone rangers. Okay, they keep saying they like their own company. That is fine. But please, when it comes to this one, get a friend of yours, 1 or 2, form a group, 5, 6, 10, discuss these things. It will be very easy for you to save you time. So I know you can cram yourself. Also, you can't cram. You can't cram. Some of you are known. They're known crammies from campus. You can cram everything one night to exams. Don't try that one here. We will bury you like straight. You will die. You can't cram. So just try to understand. The easiest way to understand is to get a group of few people and go through these things. They're not so hard. Okay, so that is the Constitution. So you need to understand the Bill of Rights very well. There are not so many things. Understand what goes into the Bill of Rights and the associated legislations. And then the other things that you need to understand is now the special legislation like the Court of Appeal rules. You need to understand the Court of Appeal rules. You need to understand the Employment and Labor Relations Court rules of 2016. You need to understand the ELRC Act and also the ELC Act. That in terms of jurisdiction, we will discuss that. Nothing much, but the most important thing you need to understand is the civil procedure rules, the Constitution, and the few cases. Those few cases that you know, the normal cases, Jello versus Cartman Brown. Okay, those obvious cases. You need to understand those cases that sets, a precedent. You need to know them. The normal Jello versus Kasman. If you talk about the question jurisdiction, Caltex oil, you need to understand those cases. Don't go looking for, the whole Kenya law and no. This is a procedure. We don't care about the theories of what the court said and what, unless it is a precedent that was set under common law through a specific case. So don't, again, kill yourself. Now, with that said and done, I want us to discuss the question of decision to litigate. Okay. Now, you have sent a demand letter, and the counsel for the defendant has said, "Let us meet in court. Let us go to court. You want to go to court? Let us meet there." So, what is the next step? The next step is for you to sit back in your office at all times, guys. Every time you get a question, you need to ask yourself, at what time of the procedure is this question coming in? If we are already lodging an appeal, you don't discuss the questions that I'm going to discuss right now. If you already talk about preparing a defense, you don't discuss this. So these are things that will begin. They will come at the earliest of opportunity. Decision to litigate. Now, if you look at the past papers, specifically at November of 2021, you look at the April of 2022 and October of the same year, you realize that the same question 1 has almost the same thing, which is, what are some of the things you will consider before you pen down a pleading or before you go to court? It is very important for you to understand that bit. So there's no excuse, guys. There's no excuse. You need to understand them. So the first thing, guys, I don't want to rush you guys into. We could discuss this entire unit in just one sitting. But I'm moving specifically very slow because I want you to understand where we're coming from and where we're going. So we have seen all these things. You've interacted with this person, you've gone out for tea, you've gone out for coffee, you've talked on WhatsApp, on emails, on chats, you've done a legal opinion, they've considered it, they have, now they're giving instructions. Wakili, twende kotini. So at that moment, you need to discuss certain things or you need to consider certain things before you go to court. And those things are called decisions to charge. Alan, why are you in the dark? Your video is on, but you're in the dark. Are you visiting a witch doctor? Alan?
I am here.
Not you. There's another Alan that is opening his eyes. We can see his eyes in the dark. Are you visiting your grandmother to handle this matter traditionally? You can't bewitch yourself into passing CLE. Don't let a witch doctor eat your money. Hiyo pesa nunua nao kahawa na ukunywe na usome. Hata uende Kitui mara ngapi haitakusaidia. So Alan, thank you very much. and please mute your video. Sawa. So we are at the point where we're discussing the questions to do with decision to litigate. Okay, so what are some of the things you will consider before you go ahead and litigate? So I want people to put up their hand, at least tell us one of the things you will consider, and then we shall discuss and see how they plug into this discussion. So the first one, somebody put up your hand. What do you think are some of the things you need to consider before you go to court? They have told you to proceed and go to court. What are the things you're considering, guys? These are things you know every time. Just say them. Even the wrong ones, just say them. There is no right or wrong answer. Okay. Silas, brilliant. What is the first one?
There's an actionable cause.
Cause of action. Thank you. There's a cause of action. Somebody call Oma Akinyi.
We look whether there is conflict of interest, and if there is conflict of interest, we can not proceed.
Yes, the conflict of interest, it will come under something we are calling the ethical considerations. The ethical considerations. Some of the things you will look at. Okay, we'll discuss that. Somebody call Nyamoko Omogeni. How are you doing? Long time no see.
Sorry, I traveled, but I'm around and now I'm back and available. May you the jurisdiction? Which
the jurisdiction? Yes. The jurisdiction. Jurisdiction is everything. Without it, the court must put down the tools. Susan Mora. What else do we consider? Something very important you guys have not mentioned. Muriuki. Susan, yes?
We ought to look at the limitation of actions.
The limitation of actions. Of actions. Thank you very much. Yes, somebody called Tracy. Tracy Odhiambo. Tracy Odhiambo, we can't hear you. Kivuti Dorin.
Yes, look at the parties.
Very important. Parties to a suit. The parties. Okay. Let us go to Foro Hamed. What else do we look at?
I'll also discuss the legal fees.
That falls under the ethical considerations and other considerations. That will form out. Of course, you have to discuss the question of fees. That comes under those considerations, other considerations. Simel. 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 Okay. Silas. Muriuki.
Venue of the court.
Come again.
The venue of the court.
That has already been said. That falls under jurisdiction, the forum jurisdiction and the venue jurisdiction. Okay, we will discuss that in a few. Odur Alan, lastly.
We will look at the chances of succeeding in that suit.
The feasibility, very important. Feasibility. Don't just go to court because you've been paid. Okay, don't go to court because you've been paid. So those are some of the things we are going to consider, and we are going to discuss each of them as we proceed. But the most important thing, guys, that I want you to understand, thank you guys, put down your hands. The most important thing you need to understand is why. Understand the concept and ask yourself why we consider it. Because if you understand that, then it will help you. Alan, mute your microphone. If you understand that bit, it will help you understand. Guys, the most important question you need to ask yourself all the time as you read is why? Why is this happening? Why is this? Why do we need jurisdiction? Okay, or what is jurisdiction? So we're going to discuss that in a few. So like everybody else. Yes, please.
Can I ask na legality?
What do you mean legality?
Like, where does that come in qua interview or after? Like, for example, somebody can't come to you with a case involving something that is illegal, like alibaki na pesa yangu ya kuuza bangi, something like that.
That falls under feasibility now. Is
Okay,
it
thank
something? Is it a legal dispute? You know, you can still take it to court. You can still take it to court, and you will win. You know, you will win. But remember that once you win the civil case, then the police will just pick you up. But also they can't pick you up based on your own testimony, unless you bring the bangi itself to court. You know, saying that I have bangi is not a crime, or saying that you smoke it is not a crime, or posting a picture of you smoking it is not a crime. The crime is being found with it. That is a crime. So if you can still go to court and say, hey, I sold this guy something, okay, but he's not paying. So it depends. It depends. Again, it depends how good or how bad your lawyer is. You can walk out with it. You can be very successful in prosecuting that matter, or you can end up in jail, you and your lawyer. Takuwa kamiti nyinyi wote wawili. It depends on how well you draft and how well you can fight. Okay? So that is that. Thank you. So we've talked about the question of feasibility. Like I've said, feasibility is what are the chances of this thing? Is it a moot question? Is it a moot question? Is it something? Is it a cause of action that is still existing? Is it something that we should take to court? It's a reasonable test. Just objectively, should we take it to court, or is it something that the two of them can just sit down and talk about? For instance, if you are fighting about 1,000 shillings, you can take it to the small claims court, but even the filing fees at the small claims court is 1,000 shillings. So you will spend more money litigating that matter than the actual pecuniary value of the case. So that falls under feasibility. Is it a feasible dispute to take to court, or does this make sense, objectively speaking? So that is the question of feasibility that also looks at the question of mootness and everything else. Now, course of action. What is the course of action? Now, it is very, very important for you to understand the course of action, which is the why. Now, when you go to your course outline and you look at topic 6, that is the commencement of civil litigation, you will not understand commencement of civil litigation unless you understand what is a course of action. Okay, we are still at the stage where we are saying this person is still in your office, if you have an office, or this person is still texting you on WhatsApp, telling you what is disturbing them, what is bothering them. That is still, we are still at that stage. We are yet to go to court. So once we decide to go to court, before that, there are things we need to consider. And then once we do that, then we are going to invoke the civil procedure rules. You don't go to court before invoking the civil procedure rules. So we are not talking about the rules yet. We are still talking about the obvious things, what you would consider in your law firm, or before you advise a friend or a relative to go to court. So the course of action, which is the course of action? So what is the dispute? What is the legal dispute that has been presented by the pattern of facts you've been told? You've been told this person is saying some tweet that was posted by this person on their X account. Then from that, you need to know this is now a question of, this is a tort of negligence, or it is a tort of defamation, or it is a tort of trespass, or it is strict liability. So from there, you need to understand those aspects, because again, these are things that you did in your undergraduate. You need now to incorporate them. Be very patient with yourself. Again, don't beat yourself up. Don't. Okay? Guys, I've said it is okay not to know, but be very patient with yourself. There are things you know now that you didn't know before, but the rate at which you know them now even amazes you. The same thing. Things you don't know now, you will know them. Just give yourself some time. So don't kill yourself. Don't say, I don't understand these things. They don't make sense to me. Relax. Chill. Yeah? So take time to understand. So that is the question of courses of action. So you need to understand what is the course of action here, because the course of action will define two things. Okay? It will define how you draft. It will also define which court you approach. It also defines jurisdiction, because the course of action defines jurisdiction. Are we together? So it's very, very important for you to understand what is the course of action here. It is a tort, okay? Or it is an employment question, the violation of labor relations. Or this is a question to do with the contracts, a breach of contract or a contract related thing. Or this is a question to do with violation of fundamental human rights as provided for under the Bill of Rights. So you need to know, why is this person going to court? Why? What is the course of action? The course of action is, what is the dispute? Guys, all of us can read and understand English. Okay? So you guys have passed your primary school where you didn't know how to read and write. You've still passed. You went to high school, the same thing, you passed. You went to very good campuses, you still passed. You will still pass this one. But make sure you reduce these things to the basic, to the bare minimum. Just don't complicate them. Just ask yourself, what is this? What is this thing called the course of action? This is the dispute. What is the problem? Shida ni gani? Hiyo shida ni gani, quote unquote, that is the course of action. When two people come to you and they're saying, hey, huyu amefanya hivi hivi na hivi, then the question is, shida ni gani? That shida ni gani thing is the course of action. Okay? So the course of action must be there. Now, once you understand that, then an automatic case will come to your mind. There's a case that discusses the question of courses of action. This case, everybody knows it. The moment you get to the Kenya School of Law, if you're speaking to a new student at the Kenya School of Law and they quote this case, utajua huyu ni form 1 huko KSL. Which case is that? Somebody? In terms of cases, courses of action. Everybody knows that case. Somebody put up your hand. Inango Yusra.
Mukisa Biscuits versus Western Distributors.
Thank you very much. Mukisa. That is a case that everybody knows. If you want to appear complicated in a legal debate, you just mention Mukisa. As per Mukisa. You don't say anything else, just say Mukisa. Na unanyamaza. Mukisa Biscuits versus Western Distributors. That is Madanjai. So this case helps you understand that you don't file a case before determining what the course of action is. At the same time, it will help you in understanding Order 2, Rule 15, which is the question of dismissal of suits, that a suit can be dismissed. Why do we dismiss a suit? Because number one, the suit does not disclose a reasonable or a triable course of action. A course of action. A course of action is the dispute to be litigated upon. So that simple thing, you see the way it connects. So we are saying you need to determine the course of action. Because when you file this case without a course of action, then we will dismiss it under the Rule 15. And that brings the question of now applications for dismissal of a suit. That is Order 2, Rule 15. Okay, what is the first ground? It does not disclose a course of action. We can still also link this thing to summary procedures under Order 36, where a defense has been filed, but the person that has filed the defense, the defendant, is not, or the defense itself is not raising a tribal issue, is not raising a course of action. You can strike out the defense and then claim summary judgment. So these things are interrelated, interconnected. Once you understand at the back of your mind what is a course of action and why do we need it, then these things will just start ticking in. There are things you know. Ni vile unajipea pressure mingi. So don't pressure yourself. Kula, ulale, kidogo tu, usilale sana pia. Just as zingine watu nalala. Sleeping will not make you glow. If somebody lied to you that you will glow, sleeping makes you glow. In your dreams, you don't glow when you sleep. So please, sleep vizuri, get good sleep, but don't oversleep. You know, some people sleep as if that is their right. You know, you sleep as if it is your right. You are created to sleep. Come on. Even the Bible says, as you sleep, you know what will happen to you. It will creep upon you. So, fellow Christians and Muslims, I'm also very sure the Quran is against people that sleep too much. Maybe somebody can confirm. But don't sleep. But get enough sleep, but also don't sleep too much. Also when you have exams going on. So that is the question, of course. I'm just highlighting, but I want you to see the interconnectedness of these aspects, because at the back of your mind, you need to have a very strong foundation of what civil is, and then you can move forward together. The next thing is the ethical considerations. You need to consider whether there's conflict of interest, they can pay their fees, this is a matter that has been litigated before or what. Those are things that fall under ethical considerations. You need to understand the question of limitation of actions. Very, very important. And you need to understand it as a concept. When I say you understand it as a concept, I will come to you and I'm telling you, hey, this matter, or I was knocked down by a car in 2015. I just woke up right now and I want to sue. How do you help me? But if you understand the question of limitation of actions and the relationship between that is the Limitation of Actions Act, that is the Statute of Limitation, Order 37, and Order 50 Rule 6, you will know how to go about those things. Now, let me give the relationship between those things that I've said. I've said the Statute of Limitation, I've said Order 37, and I've said Order 50 Rule 6. So let's start. When you talk about the statute of limitation, it provides for the period upon which you must bring your suit. If it is a suit that is based on a contract, breach of contract, 6 years. If it is a suit that is based on a tort, and we have different types of tort: defamation, negligence, trespass, state liability, civil battery, all those things, they will fall under torts. 3 years. So after 3 years, you're out of time. If it is something that is about execution of a judgment or a decree, 12 years. After 12 years, you can't bring it. Are you together? So then therefore it means that you need to understand that when you are out of time, as per the statutes of limitation, tort, contract, judgment, and everything, that requires a specific number of years to be instituted and you're late, then you need to seek what you're calling enlargement of time or extension of time. Enlargement and extension is the same thing. So don't say, oh, this is now enlarging, this is extending. No, just have it the same thing. So when you are going to extend the time for bringing a suit through a plaint or whatever, you have to do that through Order 37. Okay, you have to bring it through summons, and Order 37, you do an OS, originating summon. Guys, originating summon. You do that through Order 37, which is originating summon, and you're praying for an extension of time for you to institute your plaint, petition, originating summon, or even a statement of, or just a plaint, whatever statement, counterclaim, and anything else. You have to get that leave through Order 37. Now, let us go back to the civil procedure rules. Now, the civil procedure rules provide also the same way the statute of limitation provides for the specific timelines, the specific number of years that you are supposed to, after which you're supposed to bring a suit, or before they elapse, you're supposed to bring a suit. The same way, the civil procedure rules provide for the timelines. For instance, if you are served with a plaint, you have 2 weeks, 14 days to file a defense. So that timeline is fixed. If you're told to, if you're given an interlocutory order under Order 40, you need to serve it within 3 days. So those timelines that are fixed within the civil procedure rules, you enlarge them through Order 50 Rule 6. And that brings the difference. So if it is anything within the rules, Order 50 Rule 6. If it is anything within the statute of limitation, originating summon, Order 37. Guys, are we speaking the same language? Tuko sawa kabisa? Tunasikizana?
Yes, tuko sawa.
Tuko kabisa. Okay, fine.
Yes, we are.
All right, so you need to understand that. So if it is anything within the statute of limitation, that is the Limitation of Actions Act 37. If it is anything that is out of that but within the rules, that is the civil procedure rules and the act, you go through the question to do with Order 50 Rule 6, and that application is a notice of motion application. Are we together? That's fine. So that is limitation of actions. Parties to a suit. We have an entire topic on parties to a suit. Who are the parties to a suit? So first you need to know who are you suing. If you sue the wrong person, you are going to get nothing. Okay? So you have to know the parties. Who are the parties? The plaintiff, the defendant, the claimant, the respondent, the petitioner, the respondent. Who are they? The applicant and the respondent. Who are they? Okay? You need to know them. And then also you need to understand now the question to do with jurisdiction. And that is where I want us to start. But before we start on jurisdiction effectively, because this now leads us to now the actual civil litigation, you need to understand that the civil procedure rules or the civil procedure litigation process is not covering some aspects. You find it, you go to court and you find civil procedure rules not applying. The first one is the question to do with probate. Okay, the question to do with probate, you don't follow the civil procedure rules except under Rule 63, where specifically it allows for the application of Order 14. Nasikia hiyo. Nimesema, when it comes to probate matters, we have the probate and administration rules, the P&A rules. So the probate and administration rule is a sister to the civil procedure rules. The civil procedure rules will apply to the traditional conventional litigation, while the probate and administration rules will apply to the probate matters. The next one is the question to do with the matrimonial issues. If you have matrimonial problems with your spouse, okay, matrimonial issues. Najua nyinyi kuna watu wengi hapa wako na matrimonial issues hata kabla waingie kwa matrimony. Wako na vituko sana. I know when I mentioned that topic, most of you are very emotional right now. Itakuramba, endelea kupendana. So if you have matrimonial issues, then we have the matrimonial procedure rules. We have the matrimonial procedure rules that will govern the court on how to deal with your divorce matters and everything else. There are rules specifically for that. Even the forms you're going to file are prescribed under that rule. The same applies for questions to do with insolvency. When you are broke, we don't view you as a normal. You don't part of the community. You don't belong to the clan. Okay, so broke men and women and broke companies, we treat them differently. Therefore, we have the insolvency rules that applies to these guys, special class of people that are broke. So we have the insolvency rules. So any procedure that you want to bring under insolvency, including the appointment of trustees, the appointment of administrators, appointment of liquidators, we do it to the rules. Okay, and also the Act creates, the Insolvency Act creates specifically the Rules Committee to make sure that there are rules that have been put in place to operationalize the Insolvency Act. A discussion for another time. Okay, so those are some of the instances where we exclude those aspects. Okay, so other things we will discuss in terms of special courts and special procedures, everything else. In terms of appeal, of course, you know that the Court of Appeal is not bound by the civil procedure rules because the Court of Appeal has got its own Court of Appeal rules. But to some extent, it borrows from the civil procedure rules as well. We will discuss that, don't worry. Now let's talk about jurisdiction. Okay, jurisdiction. Lillian S. versus Caltex. Okay, Justice Nyarangi says what? That jurisdiction is everything without which the court must put down the rule. So you must understand jurisdiction. So it's very, very important for you to understand jurisdiction. And we are going to start from the jurisdiction of courts. Jurisdiction of courts. Okay. Now, we are going to start from the lowest. We are going to discuss the lowest to the highest. But also remember that we have special courts. Okay. We have the court martial. We have the children's court. We only have one children's court. But anyway, so the children's court, the court martial, anti-corruption court, these are special courts. We'll discuss them sometime as we proceed. So the last one is the small claims court. The small claims court has a jurisdiction, is a commercial court. Magistrate courts and small claims courts are commercial courts. Okay, they are commercial courts. Why am I saying they're commercial courts? Because their jurisdiction is pegged to a pecuniary value of the dispute. Okay, so you can only go to the small claims court if the value of the dispute or the pecuniary value in dispute is up to 1 million Kenya shillings. Are we together? That is very, very important. 1 million Kenya shillings. Very important. So make sure you understand that point very well. Now, let's come back. When you go to the magistrate court, then it is anything above 2 million up to 20 million. That is under Section 7 of the Magistrate Courts Act. But remember, there are certain regions in Kenya that still do not have the small claims court. And that means if you are in that region and you have a matter that is 500,000, you don't go to the small claims court. You go to the magistrate court, which is in that jurisdiction because they don't have the small claims court. Also, it is very important for you to not to confuse the small claims court jurisdiction, that is the pecuniary jurisdiction, and the tracking system under Order 4. The tracking system is 200,000. The pecuniary jurisdiction is 1 million. Those two things are not related. The tracking system as a small claim is not related to the 1 million, which is the pecuniary value. Sijui kama tunaelewana vizuri. Somebody, if anyone is getting confused, by the way, if you are getting confused, you are free to put up your hand and stop me at any time. Anybody getting confused? Okay. So, Nyamoko.
Yes, Jacktone, you are right. I've been having a problem of differentiating between the two, tracking system and the pecuniary jurisdiction. I have to be honest.
Okay. So let's debunk it. So the tracking system came before the small claims court. Okay. So let's go back until before the March of 2020, because that is when the civil procedure rules was amended. Now, before March 2020, we used to have three things. Okay, the multi-track, the fast track, and the small claim. Not small claims, small claim, singular. Okay, now the rules provide if you prepare a plaint, you must tell us, is it a multi-track, is it a fast track, or is it a small claim? Now, multi-track, so many people, complicated issues will take a long time to be addressed by the court. That is multi-track. Fast track, not so many people, direct issues, and will take few days. And then the third one is a small claim. Now, the rules before 2020 used to define a small claim as any matter that is up to 50,000. So anything that is below 50,000 was deemed to be a small claim. So when you file it before the court will give it a different kind of attention. Why? Because it is a small claim. Okay, so that was the requirement. Now, after 2020 March, they amended that place. That is Order 4. They amended it. After amending it, now it upgraded the meaning of a small claim. Okay, the meaning of a small claim was amended from now 50,000 to 200,000. Okay, now that meant that if you are in a jurisdiction, you have a dispute with me and you're claiming anything that is below 200,000, when you're going to file your plaint, you can't say multi, you can't say fast track, you can only say a small claim. That is if you're filing your plaint. And that specific tracking is only relevant if you're going to the magistrate court. And that means there's a place that do not have, you're in places that do not have the small claims court. So this tracking system of small claim only applies to those matters that are below 200,000 that are being subjected to or are being filed before the magistrate court. You have to track them as small claim. But if it is in a region where there's a small claims court and it is not relevant because you will not file it in the magistrate court. But if you're filing it in the magistrate court and it is below the 200,000, why are you filing it in magistrate court? Because you don't have the small claims court in that place. If you go to Busia, for instance, I don't know whether Busia has a small claims court or Kakamega. Is there any in Kakamega? Bungoma? Shapakolo, Namakolo. Those funny names, they don't have small claims court. So if you're there, you just have to go to the small claims court, to the magistrate courts. So when you go to the magistrate courts and your matter is below 200,000, then you just write your plaint very well, but you have to call it small claim. But if you are in Nairobi, you now take it to the small claims court. That is what we are saying. And then we came up with the act. That is the Small Claims Court Act. Now that one now introduced a court called the Small Claims Court. Now the tracking system as a small claim does not mean you go to the Small Claims Court. No, it is only a tracking system to notify the court that, Your Honor, this matter is a multi-track. It is complicated. It is serious. Or this matter is a fast track. It is simple and direct. Or this matter here is a small claim. That is for magistrate courts. Memoko, tuko sawa?
Yes. Yes, thank you.
All right. So that is the end of the small claims court. So you know the small claims court is a standard form. You just download the forms, you fill them, you file them, you pay 1,000 Kenya shillings, which is the filing fee, and you wait for your order, though they really take time. It was meant to take 6 days, but core ground, V2 are very different. That is the small claims. Okay, that is the small claims. And now we go to the magistrate court. I've saved the magistrate court all the way from 20 million all the way down. Okay, and you know the different classes of the small claims. We have the resident magistrate, the senior resident magistrate, the principal magistrate, senior principal magistrate, and then the chief magistrate. So 20 million and below. Magistrate courts do not have any jurisdiction when it comes to the question of human rights or constitutional questions. I will explain by giving an example in the next statement. So there's nothing much about magistrate courts. You already understand that magistrate courts are only restricted as per section 7 of the Magistrate Courts Act to entertain questions to do with whose pecuniary value is not exceeding 20 million. Okay, so it can be from 2 million to 20 million, no, 1.01, 1 million and 1 shilling. From there to 20 million, that is where there's a small claims court, or from 0 to 20 million where there's no small claims court. You understand that? Now, let's go to the Superior Court. And I've said time without number that there is a Superior Court. What is the Superior Court? Somebody tell me. Put up your hand. You will be told that a matter was filed in the Superior Court, or the judge of the Superior Court gave a ruling. Which court is that? Which court is that? Mbuvi Gloria. Mbuvi Gloria.
The Superior Court is the High Court of Kenya.
Thank you very much. So it is the High Court. Okay, and that is why. Why do you think the High Court is the Superior Court? The High Court is the residence of the bar. The High Court is the residence of the bar. You don't call yourself the advocate of the Court of Appeal. No. You're the advocate of the High Court of Kenya. Hizo zingine za advocate of the High Court of the Court of Appeal and the Supreme Court, hizo ni kelele. Okay? Hizo ni PR. So it shows you're an advocate of the High Court of Kenya. Period. You can once you are admitted as an as an advocate of the High Court of Kenya, you can practice before any other court, because the High Court is the only superior court. It is the only court that has original jurisdiction in everything. Okay, so the main reason why the High Court is the superior court is because the High Court is the only court that has original and limited jurisdiction in everything, all civil and criminal. The Court of Appeal has no original jurisdiction. The Supreme Court has very limited original jurisdiction, only in terms of a dispute relating to the election to the office of the president. Nothing else. So it is a High Court that has unlimited jurisdiction in both civil and criminal matters. So the examiner will tell you that a matter was filed, or the judge of the Superior Court. The word superior means the High Court. And it has been defined under the Court of Appeal rules as the High Court. Okay? Superior Court means the High Court. So let's go to the Superior Court. Okay? Again, make sure you understand that the specific word superior and the English meaning of superior. So superior could mean anything that is big, but in this context, superior means the High Court. Now, the High Court has various jurisdictions. The first one is original jurisdiction. The High Court has appellate jurisdiction, and the High Court has what you're calling the supervisory jurisdiction. Very, very interesting. Okay, and then the same High Court has got its sisters, the ELC, the Environment and Land Court, and the ELRC, which is the Employment and Labor Relations Court. These are two courts that have also the courts of equal status to the High Court. Are you together? But they are constitutional courts. These courts are constitutional courts. They do not have any commercial aspect. The ELC is not a commercial court. It is a constitutional court created by the Constitution to handle constitutional matters that relate to the question of right to land or land generally. And then the ELRC, the question to do with employment. It is a constitutional court. Are you together? All right. So let's come back to the High Court. So the first one is original jurisdiction, which is of course unlimited in all civil and criminal matters. That is the first one. The second one, the High Court has the original jurisdiction in terms of questions to do with a violation of human rights. So if your human right has been violated, it is the High Court that has that jurisdiction. And where is the High Court getting that jurisdiction? From the Constitution. Where specifically? Article 165 creates the High Court. That specific article gives the High Court that original jurisdiction. Article 2.2 says, any person that is aggrieved by anyone or any person claiming that their fundamental right under the Constitution has been violated, infringed, denied, or threatened, they can go to the High Court, okay, and file an application. Article 2.3 says that the High Court shall have the jurisdiction to entertain applications that are brought under Article 2.2. Okay? Article 2.3.3 says the High Court shall have the jurisdiction to give the remedies that are listed from Article 2.3.3a up to 2.3.3f. So the High Court has original jurisdiction to entertain the questions to do with the violation of human rights. Okay, some of you here are saying, oh, we want to picket, we want to demonstrate. But if you ask them, why are you demonstrating? You as a wakili, what is the constitutional backing of your demonstration? They just know they have a right to picket. They do. But where in the Constitution? Some of you say they have a right to life. They don't know what article is claiming, is giving that right to life. Some of them are saying, oh, my privacy, oh, they don't know which article is that. And it gets very funny when you get to an exam and the examiner gives you a scenario of such aspect that somebody claimed that their data was breached. How do you go about that? Somebody claimed that they were undressed in public. What right is that? You need to know those rights. Okay, all the way from 19. Okay, that is the enforcement of the Bill of Rights, all the way to 53, the right of children, the best interest principle. So you need to understand those ones. And that's why I say, please, 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 download the Constitution of Kenya, download it and have it. Read the Bill of Rights. Just read. Kama huwezi soma, weka tu chini ya pillow na ulalie, and you pray that that information will get to your brain through osmosis or Bluetooth, whichever you decide. Just have it somewhere, okay? So that is the question of the Bill of Rights. Guys, there's no need of doing this exam if you don't want to read the Bill of Rights. It will help you understand how to prepare petitions. It will help you understand how to prepare judicial reviews, and even to argue your applications moving forward. That's the Bill of Rights. That is, the High Court has exclusive jurisdiction to entertain any application in the first instance. Okay, the High Court, so the Supreme Court cannot even entertain a question to do with interpretation of the Constitution if that question was not raised in the High Court, because it is the High Court that has the original jurisdiction on it. Okay, remember, the first one I've said, questions to do with violations of the Bill of Rights. Number two, interpretation of the Constitution. So the question to do with interpretation of the Constitution, the High Court will have the original jurisdiction on it. So the High Court will entertain it first before any other court can entertain it. Are we together? And that therefore means you cannot raise a question of interpretation of the Constitution at the Court of Appeal. Neither can you raise it at the Supreme Court. Why? The Supreme Court cannot entertain it first before the High Court, because it is only the High Court that has the jurisdiction to entertain it first. It is the original jurisdiction. Okay? And that's why we keep saying, or they keep saying, if you are going to draft your pleadings, draft them so well, so that when you appeal the Supreme Court, they don't throw your matters away, because if you raise a matter that was not raised in the High Court, they will not entertain it. Okay? Unless it's a good day. That is the second one. The third one, the third one is the question of to do with appeals. The High Court entertain appeals from the Small Claims Court, from the Magistrate Court, and from the tribunals and the quasi-judicial authorities, the tribunals. So you can appeal to the Court of Appeal, sorry, to the High Court, from the Small Claims Court, from the from the Magistrate Courts, and also from the quasi-judicial bodies, that is the tribunals. Okay? So that is the appellate jurisdiction. That is as a matter of first appeal. The High Court is the court that entertains first appeals. And these are first appeals from small claims, magistrate courts, and the tribunals or other quasi-judicial bodies. Are we together? Hilary, what is the problem? Kinango, Yusra, and Hilary. Zimeni Yukit. All right. All right, thank you very much. Sawa. So we have that, the question of appeals. Appeal is as direct. We have an entire topic on appeals. We'll discuss appeals. Now the other one is called a supervisory jurisdiction. Now this rights are mentioned. Remember, even the ELC, they will have original jurisdiction as given to them. They will have question to do with violation of those rights. Okay, I'll explain that in a bit. Let's go to the supervisory jurisdiction of the High Court. So the first one, in terms of civil, the High Court has a supervisory jurisdiction to entertain questions dealing with judicial review. Judicial review. Marbury versus Madison. Marbury versus Madison. Okay, you understand what judicial review is. The first thing I will say, again, to ease on the confusion, judicial review is not a document. Guys, judicial review is not a plaint. You can't draft judicial review. Maelawana, you cannot draft judicial review. Judicial review is not a document. It's not a specific document that you're going to draft. And that is the first thing you need to understand for you to understand what judicial review is. Judicial review is a remedy. Okay? Judicial review is like damages. It is the same class as injunction. conservatory orders, compensation. Those are remedies. They're all remedies. Are we together? So judicial review is not a document. So if you start seeing it as not being a document, that is the first thing to you understanding what JR is. Okay, so the High Court has the only jurisdiction. It is a jurisdiction that cannot be apportioned anywhere. It is the only jurisdiction that rests with the High Court and it can't go anywhere. Okay, the jurisdiction to entertain judicial review applications. Okay, that is the way that the High Court supervises what? The quasi-judicial administrative bodies. Somebody explain what I've said. What is the meaning? What is the hidden meaning of what I've just said? I've just said, through judicial review, the High Court gets to supervise, because remember, it is a supervisory jurisdiction. You supervise someone that is below you. So that is the way the High Court supervises the quasi-judicial administrative institutions. What is the blank meaning of what I've just said? Somebody. Wadau, mko hapa?
Okay.
Yeah.
John Adams, yes.
Yes, so I guess if I had a dispute filed before the Environment Tribunal, for example, and I felt dissatisfied, my understanding is that I could submit a judicial review application to the High Court as a mechanism to seek redress.
True and not true at the same time. True and not true. What you're saying is true and not true. I will explain the not true aspect of it, is that not all tribunals are challenged. Not all decisions of the tribunals are challenged through judicial review. Some are through appeals. So it depends on which tribunal. So I'm just putting it out there so that you're very cautious in terms of how to deal with it. Every statute that creates a tribunal will give you the way in which you can challenge the tribunal. Okay, for instance, the National Environmental Tribunal, you don't do a judicial review. You appeal to the ELC. You don't do a JR. But the examiner knows very well that you know the opposite. So they will say tribunal, and then you'll just say PAP. Hawa nimeshika. Hii ni judicial review. Kumbe wewe ndo umeshikwa. Okay? So just make sure you get to know the difference. So not all tribunals are addressed or their grievances are addressed through judicial review. Anyway, thank you. Let's talk to Inango Yusra.
If you want to appeal, you have to go to the ELC. If it's a land issue, and ELRC if it's a work related issue.
No.
Because
Let me say the statement again. It's a very simple thing. It's a very simple thing. I'm just saying, judicial review is the supervisory power, okay, of the High Court. Now, if some of you have been supervisors or some of you have been supervisees, if you're a supervisor, you don't supervise yourself. You supervise someone that is below you, okay, that is below you. And who is below the High Court? The Magistrate Court, the Small Claims Court, and the tribunals. Are we clear up to there? After that, I've said that judicial review is the way in which the High Court supervises the quasi-judicial bodies, like some of the tribunals, or the quasi-administrative bodies, or the administrative institutions. So essentially, what am I saying? It's important for you to understand it. Yes, somebody. Mbovi Gloria.
So, from my perspective on what you're saying, I believe the question of administrative law is what the High Court is supervising, the decision of public bodies is being reviewed by a High Court to make sure they are conforming to the Constitution. That's why they can supervise them, because the quasi-judicial bodies are under the Constitution.
Yes and no at the same time. I will explain why in a few. Let's get to Nyamoko Omugeni.
Yes, I would say the High Court, through judicial review, supervises the lower bodies by issuing the writs of declaratory writs, prohibitory writs, or comparator writs.
Who are these lower bodies? So my question is, who are these? Actually, the entire thing I want to understand.
Courts. That's the lower courts.
What I'm saying is this. What I'm saying is, I want you to answer it. So my question is, who are these lower bodies? That is exactly what I'm asking. Who are the lower bodies? Nyamoko?
The lower bodies are the magistrate courts, the quasi tribunals, that's the court martial, the county courts, the children's courts, and then any other administrative, government administrative bodies. Like now, if KSL makes a decision that infringes on a student's rights, the student can maybe, if upon the KSL's body fails to resolve that or makes a decision that is ultra vires or infringes on a student's right, then that student can run to High Court, seek through judicial review, seeking for a remedy, either to prohibit KSL from implementing whatever decision it has made, or compelling KSL to act as required by the law.
That is true. Thank you. That is true, but part of it is not true. So I want somebody to correct what Nyamoko said, and give me the correct thing. There's a point I'm looking for. Manyasa, Silas.
To say that I want to correct him, but I'll try to give my understanding of JR. The way I understand judicial review, it's the process. Yes.
Calm down. The question is.
Yes.
The question is, what are these people, or who are these people that are being supervised by the High Court through judicial review? That is a simple question that I'm asking. Nyamoko has given an answer. So from that answer that he has given, I want you to correct something, and then you can all proceed.
Okay. From what Nyamoko has given, the bodies, or rather the bodies that he has mentioned, he's mentioned primarily courts, but when we're talking about JR, it refers to those entities performing functions that would be performed by courts, and maybe you can talk about when you look at, for example, a decision made by the advocates disciplinary tribunal, for example, if the decision was not made as stipulated in the law, then the aggrieved party.
Hello? Silas.
Yes.
I get your point. You're very close home. Let's talk to Ijaka. Victor. Thank you, Silas. Guys, this is a very simple thing. Somebody just complete what that was Silas has said. Victor, Ijaka, are you there?
I'm here. You getting me?
Mm-hmm.
Okay, my understanding is when the High Court supervises the administrative aspect of administrative bodies and also the judicial officers and a judicial process, the administrative aspect of it. You cannot do a JR on a judicial process, but you do a JR on administrative process of the same.
Alan Oduor.
Yes, I think that my brother, Mr. Nyamoko, has mixed up a judicial review with appeals to the extent that he has indicated that these are judicial review matters, but they're actually appeals from lower courts and quasi-judicial bodies. To me, a judicial review is more like a petition on a specific issue, which is not arising from. Yes.
Calm down. Calm down. Question, guys. Very simple question. The question is, supervisory jurisdiction of the High Court through judicial review. You can't supervise who is below, who is above you or who is equal status with you. Who are these people that the High Court supervises through judicial review? That is the question. So when I give you the mic, tell me this person, this person, this person, this person. Ombai, Kevin, Odhiambo.
Yes, thank you, Jacktone. So the supervisory jurisdiction of the High Court simply the High Court supervises courts that are below the High Court, that is magistrates' courts, and then the tribunals. Because if you read Article 159, we have the judicial authority that is being exercised by the courts and tribunals. So the High Court being one of the courts, and being that it cannot supervise the courts that are above it, then it supervises the courts that are below it, and then the tribunals. Because so from there, the concept of JR arises, but then now it depends with specific tribunals. But then the specific answer I would give is the courts that are below the High Court and then the tribunals. Yes.
All right. Somebody save me. Thank you, Kevin. Yusuf Noor.
Can I say public bodies and private bodies?
Nope. Yes, that is true, but call them by the name. There's something simple that I'm trying to test because I want it to become very clear. And Silas had mentioned it and is not.
Administrative bodies.
It is, but you're not giving me the specific answer that I'm looking for. Dairas Kenyaga. Dairas Kenyaga.
Malimo, I was on the mic before I was interrupted.
Hello.
Your mic was been taken, my friend. Dairas Kenyaga.
Oh yes, hello. As we've talked about in the class previously, we talked about the authority of the courts to uphold and enforce the Bill of Rights, and thereunder we have the remedies, that the reliefs that the court may grant, which includes an order of judicial review. And when you look at Article 19 of on application of the Bill of Rights, it states that the Bill of Rights applies to all law and binds all state organs and all persons. So the supervisory jurisdiction here is that the High Court may order and may issue an order of judicial review to all public administrative bodies, all bodies doing administrative functions, either public or private, as well as the courts below it.
Okay. Guys, should I put a price? I need to put a price to this question so that somebody can walk home with a prize. Guys, what am I asking? And why am I asking it? Because I want you to understand something when it comes to judicial review so that you don't confuse it. I thought Silas had already explained it a little bit, just a little bit, but he deviated. I wanted somebody to pick it from there. So I'll give the last person to explain. Yusuf Noor, do you have, I'm asking you, who are these people that are being supervised by the High Court through judicial review. Article 47.
Madam, these are public officers in positions of authority.
Wakili? No. Joan? 2 people only, and then you can proceed. Joan?
The Fair Administrative Actions Act has described the bodies that the court can review, can conduct a judicial review on. So they may be public or private, but they deal with public matters, is my understanding.
No, half yes. Let's talk to Anne. Anne, guys, this is a very simple thing, guys. Come on, don't overthink. Again, don't overthink it. Don't even quote a section of the law. Don't even make reference to the Constitution. Just tell me this person and this person. Assume that the High Court is your father. Assume that the High Court is your father. The ELC is your mother. The ELC cannot be supervised by your father because they are courts of equal ranks. So that means that now there are people that fall below your mom and your dad that can be supervised. So just tell me those people, and then I will explain what I mean. Whether they're public or private. Yes, they're public or private, yes. But now, who are these public or private? There's something that is not coming clear. Kamiri John, my friend, how are you from Yambu?
Kamiri John is very, very, very fine.
Yes.
Good. And my simple answer would be any public or private body that submits itself to the authority of a superior court. And the very first one are the magistrates or subordinate courts. And any other person who finds it favorable to request the court who submits by the ordinary submissions to be under the supervision of the High Court.
All right. Thank you, Kamiri John, all the way from the second capital of Kiambu County. All right. So, guys, do I need to rephrase the question again? But anyway, let's have Anne as the last person. Anne? 1 minute, 1 second, 2 seconds. Anne is not there. So the question is, let me rephrase it. I go to court. I go to the magistrate court and I seek an order. The magistrate court refuses to give me the order. I go to the tribunal, the advocates tribunal, and they suspend me. Which of these two? Okay, let's say Kamiri John is suspended by the advocates tribunal. Okay. Myself, I've been given or I've been suspended by the court, the High Court. The magistrate court. Between Kamiri and myself, who is going to the High Court through judicial review? And who is not? That is a question I've been asking all along. I'm coming from the magistrate court. Kamiri is coming from the tribunal. Who is being supervised by the High Court through judicial review? Is it both of us, me and Kamiri, or is it Kamiri only, or is it me only? That is the question I've been asking. Okay. Julius Oidaga.
Thank you very much. So I would say it is judicial and quasi-judicial bodies that are supervised by the High Court.
Julius?
Yes?
You didn't get the question.
Okay, the question, the answer would be...
You can't give the answer if you don't get the question. The question is... Okay, the question is... Kamiri from the tribunal, myself from the magistrate court, who, between the two of us, who is going to the High Court through judicial review? Is it both of
Kamiri.
us or just me or just Kamiri?
Kamiri.
Why Kamiri and not me?
Because
Can I try?
Can I
Who
try?
is that? Who is
Silas.
Who is speaking? Yes, Silas, proceed. No, Silas, wait. Silas has spoken. Somebody's just requested the mic right now. Who is that?
Okay, it's okay, Mwalimu.
Somebody's said, can I try? Who is that? Kinango,
Yes, sir.
was that you?
Yeah. Yes.
Uh-huh.
I believe if you're coming from the magistrate court, having in mind that when you're filing the application, you have to ask for leave of court. I believe now it's the person who has the administrative issue and not because if a person goes from a magistrate court to a higher court, then that's just you're just appealing. You're going to a higher court. But if you're going to, you have to like seek leave and it's an administrative issue that you want to be supervised, then
So
the
what is the
person
answer? What is the
the
answer to the
answer,
question?
the one who has been dismissed, not
All
the
of
one
us
from
have,
the
all of us have been dismissed. Okay, guys,
okay.
let me make this. Let me answer the question, and then you can move.
Mwalimu, can
You
I
can
answer
move.
that question?
If you get it wrong, I'm going to have you abducted. If you get it wrong, you're going to be abducted. You need to send me your location so that I can send guys who kusalimia. Silence.
You see, the answer is the person coming from the tribunal.
And why?
The reason is because judicial review is there for the High Court to supervise as a remedy for decisions made by quasi-judicial bodies, and a tribunal is a it's performing functions similar to those the court would perform, so it's a quasi-judicial body.
Well, so don't use the word quasi. Use another word.
It's performing administrative functions. No, I can't find the right word.
Can I try?
Yes, Mugen. Close it up.
And I
Close it up.
yes. Thank you for the chance. I said any judicial reviews to the High Court can arise from magistrates' courts, tribunals, public administrative bodies, and the quasi-judicial courts.
No.
So in the scenario you gave, both of you have a chance to seek for judicial review in the High Court.
We don't. Not all of us can go to that. Let me just give the simplest answer, guys. What I've been looking for that somebody needed to tell me is that judicial review is not available for court orders. Okay? Judicial review is not available for court orders. You can't challenge a court order through judicial review. If the court gave an order, you don't challenge a court order through judicial review. So myself, I won't go to the. We both go to the High Court. I will appeal to the High Court. Okay, I will appeal to the High Court, but Kamiri will file judicial review. Remember, like somebody was speaking, that was Silas. I think that was Silas that was just spoke right now, and I've told him not to use the word quasi to make it easy. The word that I was looking for is administrative. Okay, there are two things here. There's administrative bodies and judicial bodies. Courts are judicial. Any other person or any other institution are administrative. Judicial review is only available for administrative decisions. So courts don't make administrative decisions, and that is why the High Court cannot supervise the magistrate court and the small claims court, because those are courts. They don't make administrative decisions. Their decisions are not suggestions. They are judicial decisions, and they are binding unless you appeal. Okay? But when it comes to tribunals, you come to other institutions like schools, private schools, churches, circles, societies, merry-go-rounds, all those things, banks, anything. Any other body that is not a court now that body, whether it's private or public, whatever decision it makes is an administrative decision. And that decision can be challenged through judicial review. So judicial review is the judiciary reviewing a non-judiciary decision. Okay, so the High Court cannot review a decision of the magistrate through judicial review. You cannot challenge the magistrate court's decision through judicial review. That's what I was explaining. So in terms of supervisory jurisdiction, the JR only applies to decisions that are not judicial decisions, but are administrative decisions that are made by administrative bodies. Administrative bodies are all other bodies in the world that is not a court. Okay, that is what I was looking for. So after that, of course, we have the ELC and the ELRC. We will talk about these courts further, but understand that the ELC is not a commercial court. The ELC is not a commercial court. It is a constitutional court that is created by the Constitution and given a specific jurisdiction to entertain the question to do with the right to land. Right to land. Okay? Right to land and anything that touches on environment. It is not a commercial court, and I'll give you an example. Myself and Kamiri, I give Kamiri instructions and tell Kamiri, Kamiri, come and till my land or come and build my house. Kamiri has refused to build my house. I've paid Kamiri, but Kamiri has refused to build my land. Now that one is not a question to do with land. Guys, that one is not a question that touches on the right to land. That is a contract. Okay? It is a contract. It's a contract question. It is a commercial question. So I'm going to sue Kamiri to return my money or to till my land. And that one goes to the magistrate courts if the value is more than less than 20 million, or the High Court if it is 20 million and above. So I've given Kamiri a contract to till my land or to build my house. That is not a question to do with the land. It is a contractual, normal commercial dispute. The other instance is, I have bought land from Kamiri. I have bought land from Kamiri. Kamiri has refused to give me that land. This one is a question to do with land. And therefore, I will go to the ELC. Okay, now how do you know whether something is a question to do with the land or not? The simplest question is this, that you should ask all the time. Are both people claiming the right to that land? If one person is saying this land is mine, the other one is saying it is not yours, then that is a question that deals with the right to land. That is the simplest way to distinguish. So in the first instance, I gave Kamiri a contract to come and till my land. Kamiri has refused. In that instance, we are not fighting over the land. We are just saying, I gave you money, but you didn't do the work. That is a contract. Kamiri is not claiming my land, neither am I claiming Kamiri's land. No. But in the second instance, I bought the land, so I want that land. Kamiri had that land. I gave him the money, but he has refused to give me the land. So the subject of the dispute is, give me the land. The land is mine. I bought it. So that is a question to do with land, and therefore it goes to the ELC. Section 13 of the ELC Act provides for the jurisdiction of the ELC. Okay, it provides for the jurisdiction of the ELC specifically and very clearly. So also visit that so that you can understand. But I've already given you the example. We'll look at this more and more as we proceed. But I've given you an example of what could be a question to do with the land and what could not be, or what is not a question to do with land. So the question is, what is the subject of the dispute? Is it the land or is it the money? If it is the money, which is the subject of the dispute, that matter goes to the magistrate court or to the High Court, depending on the value of the dispute. If it is a question where somebody is asserting their right to land, somebody is saying, I have a right, this is mine, this land is mine, then in that instance, it is a question to do with the right to land, and therefore you go to the ELC. Now, the ELRC has been given a very specific and special jurisdiction to deal with everything that touches on employment, every dispute that arises out of employment. The simplest question in terms of jurisdiction as per section 12 of the ELRC Act is any dispute that arises out of employment or an employment relationship. Okay, that is what will give us the jurisdiction of the ELRC. So if you're just walking in town as a pupil, aimlessly, while listening to music, and your boss follows you and knocks you down with his motorbike, you can't sue your boss in the ELRC. It's not a question. That is a normal thought. Even though your boss is the one who has knocked you down, it is not a normal. It is not a question that comes out of employment. Okay, they're not doing that as your boss. They're doing that negligently as a normal human being that was passing and knocked you down. But if something happens in your employment, in the context of employment, then that thing must be addressed before the ELRC. Okay, and of course you will discuss the ways of approaching the ELRC later in time, but you know that when you're approaching the ELRC, you can either do a plaint, you can do a statement of claim, you can do a petition, and you can do a judicial review. So if it is anything that is just the normal pecuniary aspect of unfair dismissal or this and this, you can do a statement of claim and you claim reinstatement or compensation or damages. If it is a question that deals with your right in the context, for instance, discrimination at the place of work, that one you could do even a plaint. Sorry, even a petition where you are claiming that you are right under Article 37. Sorry, not 37. Your right under Article 27 has been violated. That is the right to non-discrimination. If you have been treated in a manner that violates your right to dignity or privacy in the place of work, you can still do those two aspects. You can do a JR, you can do a petition. Okay, so that is what we mean by the ELRC. So ELRC is easy, anything that is employment related. But also remember that the Chief Justice has the power and has always exercised that power to apportion the jurisdiction in terms of employment to specific magistrates. So there are certain matters that will be filed before the magistrates. Though they are employment matters, in practice, that only happens in practice. In practice, there are matters that you will file before the magistrate, and specifically because the Chief Justice has given the magistrates those powers because there is need to reduce the backlog of cases in court. So what is the parameters? So any matter that is below, if your basic salary is below 80,000, kama unakula chini ya 80,000, then you don't have the privilege of seeing a judge. You go straight to the magistrate. So look at your pupillage contract and see if your boss is paying you anything that is more than 80,000. If that is not the case, in case your boss fires you unceremoniously, you can only sue them before the magistrate court in practice. But if you are to draft an exam question, that matter goes before the Environment and Land Court. So there's practice bit of it and there's actual, there's the legal bit of it. So the legal bit of it is any matter that is coming from an employment aspect must go before the ELRC. The ELRC has got its own rules of 2016 that describes how you approach the ELRC. But both the ELC and the ELRC are constitutional courts, and they handle specific constitutional questions. You can approach them through plaints, you can approach them through judicial review applications, and also through petitions. So that is the ELRC. So quickly, as we summarize, we have the Court of Appeal. Very simple. The Court of Appeal has only the appellate jurisdiction. The Court of Appeal only has the appellate jurisdiction, and of course, limited original jurisdiction in terms of contempt of court. The Court of Appeal can deal with you right there and then when you misbehave before the Court of Appeal. So it has very limited original jurisdiction, but ordinarily, the Court of Appeal only entertain appeals from specific tribunals and also from the High Court. Appeals from the High Court. Okay? Appeals from the High Court. So that could be the first appeal or the second appeal. First appeal means that you're appealing for the first time from the High Court to the Court of Appeal. Second appeal means that you had appealed from the magistrate court to the high court once, and then now you are going to the Court of Appeal for the second time. Somebody is saying something. Let me see. No. We don't have Yusuf. We don't have. There's no tribunal that exercises judicial authorities. None. They can only exercise quasi-judicial. Quasi-judicial. Okay. So those bodies are not courts. We have the hierarchy of courts. We have the judiciary. Okay. We have the judiciary. Are we together? Now you know how the judiciary is arranged from the Supreme Court, Court of Appeal, High Court, and all courts of equal status, and then the subordinate courts. Subordinate courts, we have now the Children's Court, the Court Martial, the Anti-Corruption Court, we have the Magistrate Court, the normal Magistrate Court, and then we have the Small Claims Court. That is the end of courts. So anything aside from that is a quasi-judicial body. It exercises the powers that can be exercised by the court, but they are not courts. That's why we are calling them quasi-judicial. It means they can't exercise full judicial authority. They don't exercise full judicial authorities. They can only, even the parliament itself sometimes can be a quasi-judicial body. The parliament can do certain things that can be done by the court, the Senate itself. So anybody that can sit and pass an administrative decision, including some tribunals, then they can also act or pass a quasi-judicial aspects. But remember, let me say, so that you let me give you an example. You have NEMA, okay? From NEMA, if you have problems with NEMA, you go to the National Environmental Tribunal. So any decision of NEMA is appealed to the National Environmental Tribunal. And then from the National Environmental Tribunal, we go to the ELC. You appeal to the ELC. Now, NEMA is an administrative body, okay? The National Environmental Tribunal is a tribunal, but this tribunal sometimes it acts or it carries out some quasi-judicial functions. Okay, for instance, it entertains appeals from NEMA, or any other decision that is by NEMA that you want to challenge. You challenge it through the NET, that is the National Environmental Tribunal. So this tribunal will normally conduct itself as a quasi-judicial. It is not a judicial body, but it is performing functions that should be performed by a court. So that is a quasi-judicial. So not all tribunals are quasi-judicial, but even some administrative bodies can be quasi-judicial. Okay, if you create a tribunal, for instance, that deals with the question of tax, the TAT, the Tax Appeals Tribunal, that is a quasi-judicial. So you have to go through them before you go to. So if you have to go through them before you go to the court, that is quasi-judicial. You can't jump them and go to the ELC, for instance. You can't jump the TAT and go to the High Court. That is quasi-judicial. But also other bodies can also be termed as quasi-judicial if they perform some functions that can be done that should be done by the court. But not all bodies are quasi-judicial. Not all bodies are quasi-judicials. I want you to understand that point. Was that Noor? Noor, are we together? Yusuf. Okay, Yusuf is not there. I can see you there. So that is that. So we're done with the Court of Appeal. So in terms of the Court of Appeal, we'll discuss the entire Court of Appeal, the structure, the procedures, and everything else. Okay, because we have an entire topic for that Court of Appeal. So the Court of Appeal only has jurisdiction in terms of appeals. And then after that, we have the Supreme Court. The Supreme Court is a constitutional court. It was meant to be a constitutional court, and it is still a constitutional court. Okay, it was meant to be a constitutional court, and it is still a constitutional court. We are not supposed to have the Supreme Court anyway, but we have it. So it operates the same way the Constitutional Court of South Africa happens, because that is where they copy pasted it from. So the Supreme Court has both original and appellate jurisdiction. So original is very simple. Any dispute relating to the election, to the office of the president, that is presidential election petitions, those are entertained by the Supreme Court at the first instance. It is only the High Court that has that, it's only the Supreme Court that has that jurisdiction. And then after that, we have now the appellate jurisdiction. The Court of Appeals or the Supreme Court can entertain appeals, number one, from the Court of Appeal. Now, for you to appeal, to appeal to the Supreme Court from the Court of Appeal, the matter must be certified as of great public importance. And again, the matter must be one that is touching on the application and interpretation of the Constitution. So any matter that is affecting the applicability and the interpretation of the Constitution, you take it straight to the Supreme Court. But it must be certified by the Court of Appeal. But remember what I said. Those matters must first pass through the High Court. It is only the High Court that has original jurisdiction. So the matters that you want the High Court to interpret, you must first bring them before the High Court. Then the High Court will interpret, and then it will go to the Court of Appeal, and then it will go to the Supreme Court. So if you didn't bring them in the High Court, you can't bring them later. So even if, let me give you an example. If in the High Court you had 5 issues, you cannot go to the Supreme Court and have 10. You can't. You can only have those 5. So only the matters that were raised at the Court of Appeal, at the High Court, will be entertained at the Supreme Court if it is a matter that touches on the applicability of the Constitution, the applicability and the interpretation of the Constitution. So that is the question to do with the appellate jurisdiction of the High Court, of the Supreme Court. That is the appellate jurisdiction. So 2 things must happen. The first thing, there must be certification by the Court of Appeal. Either the matter is of great public importance or it is a matter that touches on the interpretation and application of the Constitution. So that is the aspect of jurisdiction. Some of those things we will expound once we get to the question of drafting of pleadings and seeing how pleadings work. You'll see how the question of jurisdiction will come in place, because you'll be explaining what do you draft, how do you approach this court, because it is very, very important. So other than that, any question? Time for questions. So that is the end of jurisdiction. So we need to start on other aspects. Before other aspects, let me just explain 2 things. The first one is called the forum jurisdiction and the venue. What is the difference between the forum and the venue? Very simple. So the forum is the actual jurisdiction. For instance, if you're drafting your pleading, you'll be saying Republic of Kenya in the High Court at Nairobi. So in the High Court, that is the forum jurisdiction. The High Court has the forum. But which venue, which High Court? At Nairobi, that is the venue. The High Court at Mombasa or in Mombasa. The High Court in Kisumu. So in Kisumu, in Mombasa, in Eldoret, in Nakuru, that is the venue. In the High Court, that is the forum. All right, so that is the aspect of jurisdiction. We will talk more about that as we go. Of course, I don't think we need to discuss the types of jurisdiction that we have. Of course, I've talked about the question to do with the pecuniary jurisdiction. I've talked about the forum and the venue. The subject matter jurisdiction. I've already explained that. There are certain aspects that will go to the ELC alone. There are certain things that will go to the ELRC, that is the subject matter jurisdiction. Some things will go to the High Court alone, that is the subject matter jurisdiction. Geographical jurisdiction is very important because remember, in civil, unlike criminal, we have something called geographical jurisdiction. So you are supposed to lodge the matter within the jurisdiction, within the court that has the geographical jurisdiction. And you have to clearly say it. That is the venue. Okay. So in the High Court at Nairobi, why are you filing it Nairobi? In your plaint, you'll be saying the matter, the course of action arose within Nairobi, as the court has jurisdiction. Within the jurisdiction, you have to claim that. You have to clearly say that the court has jurisdiction. That is what you're calling the geographical jurisdiction. So in terms of statutory jurisdiction, this is a jurisdiction that is created by statute. Of course, questions to do with tribunals, other courts, like the small claims court has been created by statute. The magistrate courts created by statute. So they are statutory courts. Okay, they're created by statute, and the jurisdiction is given by the statutes. So that is the end of jurisdiction, but there's more that comes with jurisdiction, including drafting. But up to there, I just want you to understand the general aspect of it. Generally, capture something, at least at the end of this class, have something to write home. Okay? Questions? If there is a question, if there's no question, I can see this already time. I need to let you guys go. And yeah, any question? Like I say, guys, I don't bite people. Okay? I think I'm a very nice person. I'm just thinking. So ask as many questions as possible. I will do my best to answer all of them. In your mind, you might be thinking, this is not a big, is a very funny question. Ask it, just ask so that you understand it. Even if it's something that is as crazy as who was my girlfriend in 2026? Or who did my grandmother date in 1984? Ask those questions. Okay? Whatever, so long as there's a question in your head, put it across and you'll get the answer. All right then. Guys, I will stop the recording there. I will stop the recording. I will share it in the group once it is ready. So I will see you guys tomorrow for criminal. Same time, same place. Keep time, please. Read ahead. Just be ahead. Okay. So be ahead. We will discuss everything. Nothing, no stone will remain unturned. So don't worry about that. We'll discuss everything. So don't worry. Ask questions. Do whatever you need to do. Read on your own. Get a group as early as now. 2, 3 people, 10 people. Make it constant. Do your work. Don't be lazy. Kind of, God only help those who help themselves. At least do something also.